Good morning. In this presentation, we will see the second part of Module 4, Constitution of India. The second part is the state legislature, composition, qualification and disqualification of members and the functions. State Legislature, Article 168. For every state there shall be a legislature which shall consist of the governor and, in the states of Andhra Pradesh, Madhya Pradesh, Uttar Pradesh, Tamil Nadu, Bihar, Maharashtra and Karnataka, 2 houses, and in the other states 1 house. Where there are 2 houses of the legislature of a state, one shall be known as the Legislative Council and other as Legislative Assembly, and where there is only 1 house, it shall be known as the Legislative Assembly. Abolition or creation of Legislative Council in states, Article 169. As per Article 169, notwithstanding anything in Article 168, Parliament may by law provide for the abolition of the Legislative Council of a state having such a council or for the creation of such a council in a state having no such council if the Legislative Assembly of the state passes a resolution to that effect by a majority of the total membership of the Assembly and by a majority of not less than 2/3 of the members of the Assembly present and voting. That means whatever there is in Article 168, Parliament can pass law for the abolition of Legislative Council of a state or for the creation of Legislative Council, provided Legislative Assembly should pass a resolution for the same with a majority, and that majority should not be less than 2/3 of the members of the Assembly present and voting. Composition of the Legislative Assembly as per Article 170(1). Subject to the provisions of Article 333, the Legislative Assembly of each state shall consist of not more than 500 and not less than 60 members, and these members are chosen by direct election from territorial constituencies in the state. Composition of the Legislative Council, Article 171. The total number of members in the Legislative Council of a state having such a council shall not exceed 1/3 of the total number of members in the Legislative Assembly of that state, provided that the total number of members in the Legislative Council of a state shall in no case be less than 40. Now, until a law is passed on the composition of the Legislative Council, the composition will be defined as in Clause 3. So the clause 3 states that 3(1) states that 1/3 shall be elected by the electorates consisting of numbers of municipalities, district boards and such other local authorities in the state as Parliament may by law specify. Now as per clause 3(2), 1/12 of the members shall be elected by the electorates consisting of persons residing in the state who have been for at least 3 years graduates of any university in the territory of India, or have been for at least 3 years in the possession of qualification prescribed by any law made by the Parliament as equivalent to that of a graduate in any university in the territory of India. Clause 3(3) states that 1/12 of the Legislative Council members shall be elected by the electorates consisting of a person who have been for at least 3 years engaged in teaching in such educational institution within the state, and the educational institution should not have a standard which is less than that of the secondary school as may be prescribed by the law made by the Parliament. And clause 3(4) states that 1/3 shall be elected by the members of the Legislative Assembly of the state from the person who are not the members of the Assembly. Clause 3(5) states that the remaining members shall be nominated by the governor in accordance with the provisions of clause 5. And clause 5 states that the members to be nominated by the governor shall consist of person having special knowledge or practical experience in the area of literature, science, art, cooperative movement, and social service. Now, as per Article 172, the term of Legislative Assembly will be for 5 years and the Council shall be continuing House, not subjected to dissolution. But one-third of the members shall retire every 2 years. A person is qualified to be chosen to fill a seat in the legislature of a state if he or she is a citizen of India and makes and subscribes before some person authorized in that behalf by the Election Commission an oath or affirmation according to the form set out for the purpose in the third schedule. That means he or she should be an Indian citizen and have to submit an affidavit or affirmation before a person authorized by the Chief Election Officer as prescribed in the third schedule. Second point is, in the case of a seat in Legislative Assembly, the person should not be less than 25 years of age, and in the case of Legislative Council, they should not be less than 30 years of age. And the third point states that they should possess such other qualification as may be prescribed in that behalf by the law made by the Parliament. Disqualification of membership as per Article 191. A person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state if he holds an office of profit under the Government of India or the Government of any state specified in the first schedule other than any office declared by the legislature of the state by law not to disqualify its holder. Second point is if he is of unsound mind and stands so declared by a competent court. Third point is if he is an undischarged insolvent, that means if he is not able to pay his debt. Fourth point is if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or he is under any acknowledgement of allegiance or adherence to a foreign state. That means if he is loyal or attached to any other foreign states and he is not a citizen of India, then he will be disqualified from the state legislature. Next, if he is so disqualified by or under any law made by the Parliament, explanation for the purpose of this clause, a person shall not be deemed to hold an office of profit under the Government of India or the Government of any state specified in the first schedule by reason only that he is a minister either for the Union or for such state. That means if a person is disqualified under any law made by the Parliament, he is not supposed to hold any post under the Government of India or Government of State even if he is a Minister of State or Union. Next, a person shall be disqualified for being a member of Legislative Assembly or Legislative Council of a state if he is so disqualified under the 10th schedule. The 10th schedule of Indian Constitution contains provisions relating to disqualification on the ground of defection, and it was included under the 52nd Constitution Amendment Act, also called Anti-Defection Act in 1985. Functions of state legislature. A bill that is passed by the Legislative Assembly and refused by the Council, then the Assembly has a right to reconsider that bill. A bill approved by the Assembly and sent to the Council is supposed to be returned within 14 days with or without recommendation. The Legislative Assembly may either accept or reject the recommendation, but the bill is deemed to have passed by both houses. The Legislative Assembly holds superiority over the Legislative Council. The State Assembly holds similar powers as that of the Lok Sabha in the case of money bill. Fifth point is Legislative Assembly members hold the right to question the ministers, move the motions and resolution, and also pass a vote of censure to drop the state government. The government ministry is accountable to the Legislative Assembly. The Legislative Assembly elects its Speaker and Deputy Speaker, who are the officers of Legislative Assembly. And the last point is the Assembly participates in the election of the President.